out. So, but I was kind of in charge of the cemetery side, and realized I voted for this bill in 2000, the one that the Secretary of State wanted to deal with in 2000. I know in 98, 99, she had a lot of hearings on. There were a lot of problems at that time, but I think after nearly 6 years, this legislation needs to be tweaked, and the tweaking I'm trying to do is set up a cemetery board. Also in your package, you have a copy of a executive summary that the Department of Audits has done. Russell Hinton gives you a breakdown. Be glad to read that to you, but rather than boring you with it, Jennifer, there should be, yes. Anyway, while she's handing that out, I'll go ahead and talk about it. But you should have a booklet also that the Secretary of State's office put out, and I'm sure Jennifer's handling it out or going to hand it out. But it gives you more detailed information that may be helpful in making your decision on the vote. But looking at the bill itself, and let me say this, Mr. Chairman, no one got a copy of this bill. Working on it for over a year, and the vehicle was there, and I told everyone, treated everyone the same. I think a lot of times when you throw bills out there or substitutes, it causes chaos, and I know today people have an interest in it, and that's the reason I wanted to hold it. The first two meetings that were set up in Ag, I had to cancel because the legislation was not right, and I didn't want to do something that wasn't right. And then last week I had to go to Florida. My wife had emergency surgery, so that's the reason for that. And then since it is a regulated industry, I thought it would be best to move it in here. And of course, agriculture, is a different committee compared to regulated industries. But if you just look at Section 1 of the bill or the substitute, this section just simply changes the definition of the cemetery and funeral services. It changes the term board to mean the cemeterian board that we'll address later on. It changes burial merchandise to include mausoleums, cremation urns, cremation markers, cremorials, and some people have been selling without any regulation. Many of you know that memorials or not mausoleums, but cities, counties have their own cemeteries. Churches have their own cemeteries, and they do not come under this regulation. We're only talking about perpetual care cemeteries that are privately owned. And one thing I was going to mention, columbariums. You probably see a lot of columbariums now. Churches, there's no rule or regulation on columbariums. You see them at churches, where people bury their loved ones, cremains. It also changes, reading on Section 1, it changes the definition of outer burial container or vault to include vaults made of polypropylene, which is a hard plastic, and other materials that have been developed since we last defined the term years ago. And it specifies that the Secretary of State, in making regulations under the Cemetery Act by and through a board. Section 2 of the bill defines principal as principal in interest. There have been some issues arising about what exactly the law means when it says you have to refund principal to a purchaser, and this defines that section. Section 3 takes care of recurring problems our cemeteries have had where they're required to provide a refund out of their own funds to pre-need purchasers. But the Secretary of State's office delays releasing the purchaser's funds from escrow has been an ongoing problem. I think the last count I had on perpetual care cemeteries, and I may be wrong on this, there are around 228 of them around the state. I can say this also, being in the industry for a short period of time, less than 2 years, this legislation it's not as tough as some other states. I know Florida's got a tougher law. I do not know if Florida has a board, But I think when we regulate an industry, whether it's the cosmetologists or the engineer surveyors, and now we're doing the builders, these people ought to be able to regulate their own industry. They have the knowledge, and I think the Secretary of State's office has done a good job up to this point, but I think it's a time to take it a step further and allow a board to serve. Let's see. I was talking about reoccurring problems of cemeteries where they require to provide a refund out of their own funds to pre-need purchasers, but the Secretary of State's office delays releasing purchasers' funds from escrow. This just provides that the escrow funds have been released promptly so that the cemetery is not left paying out its own money but unable to reimburse itself. This section also removes the restriction that outer burial containers and vaults can be delivered prior to need. Section 4 is just changing to make Code Section 1014 consistent with the way the Secretary of State operates its Section 1 through the board. Section 5 adds to the prohibited acts list in the cemetery law a prohibiting on unlicensed or unregistered people selling burial merchandise. It also raises the limit on reimbursement to cemetery owners when they have to assist an outside company in placing a monument in a cemetery. And let me stop right there. In the Act in 2000, again, I voted for the bill at the time, of course, not knowing what I know now. If someone else comes in from the outside and a monument company and installs a marker for a loved one where there's an upright or a surface marker, a single marker, or a companion marker, right now the cemetery gets reimbursed $50 from that monument dealer. And of course, anytime we have loved ones buried there and we have markers ordered from the outside, of course, the people have that right to buy them from the perpetual care cemetery or go out and shop. We always have to go back and usually fix, prepare the ground, things of this nature. Now, on a single marker, you can usually spend about $50, $60 labor, but on the upright or the companion markers, you're going to spend a lot more in labor preparing the ground after it's been placed at the head of the loved one. So this will give a flexibility to charge up to $150. They won't charge $150 each time. It gives them the option if it is a companion marker or can be an upright. An upright is a granite or marble marker. Similar change is transferring burial rights. A lot of times, every cemetery, on a perpetual care cemetery, you do have to do the deeds and deed transfer, and we have to go through the same process. We have to prepare the file and go through all the paperwork to make the transfer. It's just like buying a piece of real estate, but actually the family is selling or giving a cemetery lot to someone else or to a loved one. This section also indexes those fees to the consumer price index, so we won't have to go through the exercise again down the road. In Section 6, it creates a new licensing board, the State Board of Cemeterians, to license and regulate the cemetery owner industry. It is set up to run just like the other licensing boards in the state, and each of the new code section is based on existing laws. The board will have 6 members who are practicing in the cemetery business and 1 consumer member, all appointed by the governor. Aside from the licensing cemetery owners, the main purpose of this board will be to deal with all the issues and regulations involved in the existing Cemetery Act, which is a big job within itself. And that will bring in good business and consumer orientation toward our rulemaking in this area. And let me mention some other things, if I may, before you have any questions. You do have a copy of the vehicle that I dropped last year, House Bill 910, and most of you, I'm sure, have not read it. It is a quite lengthy bill. It's 39 pages long. And I remember when I voted on this bill, and a lot of times when we vote on stuff, you kind of hold your nose and close your eyes and hope it's the right thing. It was probably the right thing at that time, but just so happened I ended up in the business, and now I'm out of the business. But it was an eye-awakening experience for me. I think at the time the bill was done properly, but now I think it's time to try to bring it back to the center. We're not doing anything, not proposing anything on trust accounts. That needs to be done that way because it is not the money of the cemetery, it's the money of that loved one or whoever is buried at the cemetery at that time. So I'll try to answer any question, Mr. Chairman, if you allow any questions.
Thank you, Representative Rogers. I don't want to cut anybody short, but this stuff that we've been handed today is the first time we've seen it. Correct. I want the committee to take it and look at it, absorb what has been given to us today rather than start opening up for questions. We could be here all night. I would like the people in the audience that are going to be affected by this to do the same thing, to look at what we've got here, be ready to come back next week and fully debate the bill on its merits, and at that time we'll take whatever action is necessary. So I appreciate you coming, and we'll take it under advisement.
Any committee member that needs to talk to me, feel free to call me. I should be able to answer any question you have.
Okay. Has everybody got a copy of the committee substitute? Okay. Thank you, Representative Rogers.
Thank you, sir.
Next on the agenda, I'm going to call up House Bill 1445 by Representative James Mills. Mr. Chairman.
Mr. Chairman and members of the committee, thank you for this opportunity to present to you House Bill 1445. This bill simply deals with an issue that we already afford to some degree to medical facilities and physicians across this state. If you'll look at the bill on line 24 of page 1, it's only about 7 lines long, so I will read it to you first. Any pharmacist who states in writing an objection to any abortion or all abortions on moral or religious grounds shall not be required to fill a prescription for a drug which purpose is believed by the pharmacist to have the effect or the possible effect of terminating a pregnancy. And the refusal of the person to fill such prescription shall not form the basis of any claim for damages on account of such refusal or for any disciplinary or recriminatory action against the person. The written objection shall remain in effect until the person revokes it or terminates his or her association with the facility with which it is filed. And basically what that means is that if someone shows up at a pharmacist and wants to have a prescription filled that would terminate a pregnancy, then the pharmacist, if he has a strong moral or religious belief that he does not want to participate in that, he will have already filed with that business in writing that he objects to fulfilling a prescription which would terminate a pregnancy. At that point, he could return the prescription to the patient, or he could say, there's someone else coming in a couple of hours, they'll be glad to help you. But sort of a conscious clause that they have a right to choose. And this is something that if you look in the previous lines 15 through 23, we provide that basically that same thing for other people in the medical field and physician. And I certainly think other states have done this. I know that there are probably those who would say, when you present a bill, you try to imagine all the worst case scenarios, and I'm sure there are probably those that might say that, well, you're going to put people in a hardship position. What about a situation of rape, or what about a situation of sexual assault? And that's a two-sided coin. What about a situation of a pharmacist who's been through a rape? What about a situation of a pharmacist who's been sexually assaulted? Shouldn't they also have this right of conscience to, if they filed, rather than being forced by a branch drug company to step down from their position because they won't fill a prescription. And again, this person still has the option to go anywhere else and get this prescription filled. Another pharmacist could fill it, but at least this pharmacist would not lose their job over this. Now, there's already a regulation in place, but it's not a law. And the reason for the law, I think, is one reason that rules and regulations change. The other reason is, if you'll notice on lines 2 and 3 and 4 on page 2, you'll see this gives them a little legal protection so that somebody couldn't bring a lawsuit against them or a civil action and say that they caused them undue hardship or something of that nature. And I just, would ask the members of the committee to look at this with the eye of scrutiny and hope that you'll support the bill and pass it out.
Thank you, Representative Mills. Representative Mitchell.
Mr. Chairman, I think we should applaud Representative Mills for what he is trying to do. Certainly share your concerns, certainly to a great extent here, and I do applaud what you're trying to do. I think, however, what I'd like to see happen is that we get some of the more vague provisions out of the bill so that we could serve everyone's interest. I do know that very similar, as a matter of fact, identical legislation has passed the Senate with bipartisan and unanimous support, this exact bill. And if, Mr. Chair, if I may pass this information out to the members of the chair, this is the same bill which was amended in the Senate, and I can't emphasize enough, with bipartisan and unanimous support, which has the amendments that I'm going to offer to this committee here. If you would, and hopefully Representative Mills would agree that this would only help his cause, I am prepared to offer here, if we go to page 1, lines 4 and 5, where it says the following: the pharmacist believes the drug would have the effect or possible effect of terminating. Delete that and insert instead the following: the purpose of the drug is to terminate. And if we would go down to page 2, line 1, delete that line which states believed by the pharmacist to have the effect or possible effect of terminating, and instead insert the following: to terminate. That way it eliminates the ambiguity, certainly would get to Representative Mills' point, protect the pharmacist who has that objection, and therefore we eliminate any ambiguity, whereas we perhaps have some pharmacists who may believe incorrectly that the drug is to do what he may be object to fulfilling.
Thank you, Representative Mitchell. I'd say that right now we'll hold off. I will not recognize you for any motion because, and I'd like for the author of the bill then to be able to respond to it one way or the other. Representative Tumlin.
Mr. Chairman, I want to ask, on line 3, and would also be appropriate if the motion passed, on that second page you got against the person, would you consider if we put and or the employer of such person, just so a duty is not imposed upon the employer to have somebody there?
I don't see a problem with that. I think that'd probably be wise.
Thank you.
Mr. Chairman, would this be the proper time to respond to the suggestion, the earlier amendments?
Yeah, go ahead. We can do that.
I appreciate the representative's suggestion, and I would ask the members of the committee to not support that on this basis. If you limit it to only drugs that can terminate an abortion, anybody who deals, and I'm not a pharmacist, I don't have a pharmacist background, but anybody who deals with drugs in the pharmacy field will tell you there are any number of drugs that can be put together in a combination to terminate a pregnancy. And what the representative is proposing, while it may be well intended, it basically has the effect of gutting the bill entirely. And I would hope that the members of the committee would not adopt those amendments.
Representative Von Epps.
My question is, how many drugs are out there that actually are known to terminate pregnancies?
I would not be the person to answer that question. I do know that the few that I know about, your seatmate seated next to you would be in a much better position than I to address that. And I would say that the second signer on this bill is pharmacists in the House, and he did not have any hesitation. I also spoke with Representative Graves as well, and I will not speak for Representative Graves. He can do that for himself, but he has not objected to this, and I will not say any more because I know he can speak for himself. I'm not answering your question because I'm not qualified to answer it.
Representative Dean.
Could we ask somebody that knows?
I know there's RU 486, which I understand can only be prescribed by a doctor. I know that there are a combination of, the morning after pill. Again, I do not know all of the drugs that are available.
When you say combination of the morning after pill, that means that in addition to something else?
I'm going to defer to my previous response because I'm in a field, as Mr. Graves knows all too well. He could answer every one of these questions.
Representative Graves, are you in a position maybe to respond to this so we can get enlightened as to what we're talking about?
I don't know how enlightened you're going to be, and I knew I'd get brought into it, but I'll be more than happy to try.
All right.
Currently, there are 2 products on the market that are specifically used as, quote, morning after pill. And you take it, and within a certain period of time, it does not allow implantation of a fertilized egg. So therefore,
Okay.
pregnancy doesn't happen. I think part of the problem concerning Representative Mitchell's concerns about drugs specifically related to terminating a pregnancy and Representative Mills' objection to that deals with a fairly commonly known fact. Birth control pills, which are very common, taken by a vast majority of childbearing age women in the country, can be used for this purpose. It is not their specified purpose, but in the appropriate doses, it can be used for this. So what you've got is a group of people that representing the manufacturers of birth control pills and women's groups that understand the need for birth control pills, not just for birth control, but for regulation of menstrual cycles and other things. Those are important drugs in today's society. But as any pharmacist would tell you, when you get a prescription from a physician that says take 5 pills today, 5 pills tomorrow, and 5 pills the next day, you know what that is for. That is going to cause a spontaneous abortion in most cases for females that take it that way. I have discussed those 2 amendments with Representative Mills. I understand his position on it. I understand Representative Mitchell's position on it. But quite frankly, if someone wants this to happen and a physician, they can just, a lot of times we'll get a pack of birth control pills and it has take as directed on there. We don't know as pharmacists how that, we assume directed means 1 a day. What the physician has told the patient and their confidentiality of what the medication is for, we're not privy to that. So it could be taking place and we don't even know that. So to answer the question directly, to terminate a pregnancy, there's only approximately that you would consider your routine pharmacy, your community retail pharmacy. There's only about 2 products that are specifically to terminate pregnancy. Those are used as emergency contraceptive devices. And then, of course, as I stated, in birth control pills, depends on how many you take and how often you take it is what your outcome is going to be. Mr. Chairman, at another time, I'd like to offer you one other just sort of clarification amendment that I've already spoken to Representative Mills about, if I can have that opportunity at some future date.
Representative Dean.
The way the bill was explained, would you want your employees, though, how do you implement this? I mean, if Representative Graves had an employee who was a pharmacist, and a person came in with a prescription, we would allow that person that works for Representative Graves to refuse to fill that prescription based on his belief.
Only if he has filed a written statement with Representative Graves ahead of time.
Representative Mills, you really believe that that's government role to regulate his employees to the point that because of their belief that they would refuse their own for service as a business, that they would refuse to fill a pharmacy?
Certainly I do. Certainly I do. I think if someone is in prison and they are requesting a Koran or they are requesting any other type of religious, then our government goes to the greatest extent to accommodate them.
Because most of them have lost their rights by being in prison. But I'm talking about as a citizen. I have a prescription that I've gotten from my doctor. And I take it to a pharmacy that's open for business. And that pharmacy would refuse to fill that prescription based on their belief.
Only on
Not even knowing whether it would stop a pregnancy, but just on their belief.
They can do that right now, Representative Dean. Right now, they can do that under current rules and regulations that the department has put in place, and it's in rules, it's in regulations right now. They can do it. However, the problem comes if they do it and they're fired, then there's no recourse for that person, that pharmacist, who has of a good,
so they
clean
really
conscience.
can't, because they can be fired, right? And there's no recourse. So they really can't do it. I mean, they really can do it, but they take that risk of not
That's right.
of being fired.
That's right. And now if it's a private pharmacy, I think they can decline on their own. But if you are a pharmacist who's working for a chain, and maybe the chain says to you, well, you will fill that prescription or else you'll be working somewhere else, then there's no out for you possibly at that point without very expensive litigation. And what this bill would do is it would give them a legal out and protect them. And I think that's certainly within grounds. If this is
So you want the government now to regulate Mr. Graves' employees, what they can do and what they can't do.
I want the pharmacist to have the right to choose his beliefs, just like the lady has the right to choose.
Not to work for the pharmacy that hired him, but to do it according to his belief, and not the pharmacy or the owner of the facility to be able to fire him because he didn't carry out the duties as a pharmacist. You want government to protect that individual according to this bill.
That's exactly right.
Okay, thank you, Representative Dean. Representative Graves, you had a brief response to that?
Yes, sir, Mr. Chairman. Thank you. It's kind of ironic that Representative Dean used me as an example on that, because I actually have had a pharmacist that has mentioned this to me. And, of course, I employ about 5 pharmacists, and I told him, look, if that's your belief, that's fine. So he and I worked it out. I do understand Representative Mills and I had the conversation about this, though. I equate it to the unionizing of pharmacists, and I'm hiring and I'm paying them a lot of money, and they're going to tell me they're not going to do their job. But at the same time, as he adequately pointed out, the Board of Pharmacy Rules and Regulations do say that currently, under my professional, moral, ethical beliefs, I have the right not to fill any prescription today. I have that right today. Any of my pharmacists has that right. Any pharmacist in the state can say, I don't believe this is ethically, moral, or professionally correct, and I'm going to decline to fill this. What happens is, as Representative Mills said, that board process is there. Then if a pharmacist lost his job, he would have to go carry his employer before the board and say, hey, I had this right. Here's what happened. Look at this. And I can imagine if anybody took their employer before the board over that, they may be found okay, but there's going to be some other reason they're not going to be working there. To respond to that, just one more brief second, Mr. Chairman. As I said, there's only a couple of medications or so that this really is going to apply to. I bet my pharmacy, and I have not looked at any numbers, but I bet we haven't dispensed these particular products in the last year probably more than 6 or 7 times. It's not a very common thing. So I do understand the hesitancy you have, Representative Dean, but for moral and ethical issues, it's in the rules and regs, but by putting it in the code, it makes it a little easier for someone just to write me a letter and say, on these particular products, I have a moral issue with this. I just want to let you know I really don't want to feel that. And I have the amendment, if I can, Mr. Chairman, kind of gets to that.
Okay, let's.
If I can just briefly explain it, so maybe it could be discussed. Representative Tumlin kind of put some amendment in. It's on the same page 2, line 3, after the word person. I believe you already had proposed some language there. But what I was going to say was after person, provided, however, that the pharmacist shall make all reasonable efforts to locate another pharmacist who is willing to fill such prescription or shall immediately return the prescription to the prescription holder. Currently under law, the prescription belongs to the doctor and the patient at the time it's written. The pharmacist does not have any ownership in that prescription until the time that it's filled. And some problems have arisen in this area and other areas of the country where a pharmacist has this belief and is presented a prescription by the patient, and the pharmacist said, well, I don't believe I should fill this, I'm morally against this, and I'm not going to give you this prescription back. Well, that's not in that pharmacist's purview. So all we're saying is if the pharmacist isn't going to fill it, then help them find another pharmacy or pharmacist that will fill it, or just immediately say, no, thank you, I'm not going to fill this, and hand it immediately back to them so that the patient isn't drawn in to all of the issues that they may or not believe in. So I would offer that just to be sure that the patient isn't encumbered, or at least we don't hold them up. And they can
Okay, I'll recognize you at the proper time to do that. Representative Freeman.
Can you explain the written paper process, why it has to be in writing? You already said the pharmacist cannot fill a prescription of any type, and say somebody comes in and I don't have the paper on file, do I have to fill it, or can I say no, I'm not going to fill it? I don't understand the written process.
You can say no now. I think what this does is just good business. When it's in writing, there's no misunderstanding. The employer and employee both fully understand. They can put that on file and go back to. It's not filed with any state agency or anything like that. It's just a matter between the employee and the employer, and I'd really like to keep it that way.
Representative Mitchell.
Mr. Chairman, I almost hesitate to emphasize the importance of us not taking up the amendments that I had offered earlier. I will say that I am prepared to second the motion for the amendments made by Representative Graves. I think that makes sense with this legislation. But as he himself mentioned as well, is that if the employer of that pharmacist was going to have a problem with him dispensing, and you were to say that he would find other reasons, there's nothing in this legislation that would preclude that from happening in any event. I just think that this convolutes the issue, perhaps is going to cause other problems down the road. So I think we need to be very, very careful as we start to amend this code section, be clear about what it is that we want. And I think it would get to the real issue that Representative Mills is trying to get after, and certainly I share his concern for that issue.
Okay, you'll have that opportunity at the proper time. Representative Knox.
Mr. Chairman, at the appropriate time, I have a motion.
Okay. Any other questions by the committee? Representative Mills, thank you very much for your presentation. Is there anyone from the audience that would like to speak on this bill? in the back. If you'll come forward and identify who you are and who you represent.
Thank you, Mr. Chairman, members of the committee. My name is Shelley Centerfit, and I am here on behalf of the Georgia Network to End Sexual Assault, which is the statewide coalition of the 21 rape crisis centers in Georgia serving victims of sexual assault. We're here today to express our concerns about how this bill will impact those individuals who unfortunately are crime victims, who have been raped, and who have become pregnant. If I may start by just sharing a little bit of information about how often pregnancy does occur from a rape. I think it would be helpful for the committee to appreciate that. According to the National Crime Victimization Study done in 2002, there were 86,290 women raped in the United States. The estimates of rape, of course, are very low because this is one of the most underreported crimes that we have. Law enforcement estimates that you should actually multiply the number of reported rapes by 2 to 10 times to get the actual number of rapes. Now, according to medical reports, the incidence of pregnancy for one-time unprotected sexual intercourse is between 5 and 8%. So applying that number to the number of rapes that we have, RAIN, which is our national coalition of sexual assault providers, estimates that there were up to between 4,315 pregnancies to 6,903 pregnancies each year resulting from rape. I want to emphasize this is just an estimate due to the underreporting and due to other factors which may increase or decrease those numbers. The second point I want to make is that as a matter of public policy, we oftentimes do treat rape victims differently than other folks in our society. We just last week in a Senate committee, they adopted an exemption in a sonogram bill for victims of rape and incest to say we're not going to require them to view the sonogram because we appreciate that women who become pregnant as a result of rape or incest are in uniquely different circumstances from other women. I'll also just note that even George Bush, someone who is opposed to abortion, has expressed his support of allowing abortion in cases of rape and incest. So I do think that on all sides of the issue of abortion, there is a widespread acceptance that rape and incest victims should be treated with sensitivity, and oftentimes public policy should vary to accommodate their circumstances. I want to note that 8 states have enacted measures to ensure that victims of rape and incest have access to emergency contraceptives, including our sister state, South Carolina. Additionally, the states of Illinois, California, New Jersey, Massachusetts, New Mexico, New York, and Washington all have provisions to ensure that when a woman comes to the emergency room and reports that she has been the victim of this crime, she is given information and made available emergency contraceptives so that if she chooses to ensure that a pregnancy won't result from that assault, she has that option. Now, we're not here asking you to do what these other states have done, although I do hope at some point this General Assembly will consider taking that approach. But what we are here today is to urge you to consider how passing this bill would limit the options of women who unfortunately are crime victims, victims of sexual assault. Specifically, I want to call your attention to a couple of objections to the language in the bill. First of all, there is this matter of using a subjective standard, of allowing a pharmacist to state an objection to any drug which he or she believes terminates a pregnancy. There's nothing in there that even requires that belief to be reasonable or that it be a good faith belief. So frankly, a pharmacist could say, well, I think that any old drug terminates a pregnancy and I'm not going to fill it. I don't think, as a matter of public policy, that it is wise to give this unfettered discretion to pharmacists who may be dispensing life-saving drugs. A second point that I'd like to make is that y'all should consider how this is going to impact rural women, women who may not have transportation. In many parts of the state, as you well know, there may not be but one pharmacy in town. And if you don't have access to a vehicle, it may be difficult for you to go on down the road to go to another pharmacy where there may be a pharmacist that's willing to fill this prescription. And of course, in the case of emergency contraceptives, every moment counts. As you may know, these drugs are most effective when taken within 72 hours of the unprotected sexual intercourse. It's effective up to 120 hours. But the sooner you take it, the better off you're going to be in terms of the effectiveness of this drug. So if a woman goes to a pharmacy on the third day after the sexual assault, and I know y'all can imagine she's going to be traumatized right after she's been raped. She's going to be dealing with the physical, the emotional aftermath. She may not be able to go and make that decision to fill her emergency contraceptives prescription the same day she's raped. So let's say she goes on that third day and the pharmacist says no. What's she going to do if she doesn't have a way to get on down, 50 miles away to the next pharmacy? I think in a state like Georgia, y'all should really consider how this is going to affect many of your rural constituents. And the third point I want to make is how much confusion there is over which drugs actually terminate a pregnancy. I'll tell you, I'm not a pharmacist, I'm a lawyer. I didn't know anything about this area of the law until I started working on this bill. And with all due respect to Representative Graves, I know that he knows far more about this area than I know, but when the research that I did shows that emergency contraceptives actually don't terminate a pregnancy. They prevent a pregnancy. My understanding is that the drug actually works to ensure that a fertilized egg does not implant. That's very different from an abortion, in which case you have an egg that is implanted and then needs to be released. So I guess the point I'd like to make is that reasonable minds can really differ about which drugs terminate a pregnancy. My understanding is that emergency contraceptives don't, but clearly some folks believe that they do. So I fear that if you pass this bill, what you're opening up is the opportunity for folks to even deny birth control to women, which surely cannot be y'all's intent. The last point I would make relates to this issue of the fact that it's already permissible, as someone stated, to refuse to fill a drug under the rules of professional conduct. That is certainly true, but there's all sorts of reasons, in my understanding, that pharmacists can refuse to fill a drug. For example, I think on the Senate side, when we were hearing testimony on this committee, Wayne Oliver spoke to the fact that there's all kinds of reasons. For example, if the prescription looks like a forgery, well, that's a reason for a pharmacist to refuse. If y'all are going to start specifying the fact that pharmacists can refuse to fill drugs in the statute, then I would suggest that you specify all the different grounds, not just this one. Because when you start singling out certain reasons for refusing to fill a drug, then I think it leaves, as a matter of legislative or statutory interpretation, questions about, are you intending to deal with this category of drugs differently than all others? Are you intending to deal with this basis for a refusal differently from all others? I don't think that's the intent of this bill. So we would ask respectfully that y'all decline to move this bill forward, but that if you do, that you either state all the bases for refusals, all the drugs which can be refused, that you require that there be some sort of reasonable basis for a pharmacist saying he's not going to fill it, that you adopt the amendments that have been suggested, particularly the one that requires that the pharmacist refer a woman to another pharmacy, although, as I've said before, that won't adequately address our concerns. But lastly, we would just ask that you consider the women in Georgia who are raped and who do unfortunately become pregnant and the predicament that they find themselves in. We submit that this bill will really place an undue burden on those women, and we hope you'll stand with crime victims and not limit the options that they have following the attack. Thank you, Mr. Chairman. I'll be glad to answer any questions.
Okay, thank you very much.
Thank you.
Representative Mills, I'd like for you to respond to what your thoughts about her response for what has been said.
Sure, Mr. Chairman, thank you. I'd be glad to. Thank you for the opportunity. Let me just say, I didn't know exactly what was going to be said, but I kind of imagined that's what would be said. And I would just say again that those prescriptions can be filled. I have no problem with the amendment Representative Graves had showed me earlier and asked me about, could we put in the bill that they either refer to another pharmacist down the road or they give back the prescription. I certainly believe that is that person's prescription. The truth is, if you'll read current law and if you'll look on page 1, lines 15 through 23, what we already give a physician and the rights, and that he can file in writing his similar convictions. This is what we're trying to extend to a pharmacist, that same conscientious right, that they should not be put into a position to violate something they feel so strongly about, but they could simply tell them somebody else is coming in at 2 o'clock. They'll be glad to do that, but I have this conviction, and I refuse to fill this. Here's your prescription back.
Okay. All right. I think we're at the point now that we've got some amendments to be proposed. I think Representative Mitchell had an amendment, and I'll entertain it at this time.
Mr. Chairman, members of the committee, I do propose that we delete from page 1, lines 4 and 5, the following: the pharmacist believes the drug would have the effect or possible effect of terminating, and insert instead the following: the purpose of the drug is to terminate. And would also add that we delete from page 2, line 1, the following: believed by the pharmacist to have the effect or possible effect of terminating, and insert instead the following: to terminate. That is my motion, coupled with Representative Graves' motion to amendment. I think this would be a perfect bill.
Okay, you've heard the proposal for amendment. Did the Legislative Council get all that down? Working on it? Okay.
Mr. Chairman?
All right.
One thing, not to either agree or disagree, except for the fact that his second amendment, where he placed it, it actually starts on page 1, line 26. I think.
Actually, page 2, line 1 is my second amendment, where it is said believed by the pharmacist to have the effect or possible effect.
But that's not what
That's-
page 2,
no.
line 1.
Oh, okay. I have a
That's my only thing.
You're going to have to
Make
drop
sure
back
it's
to
put
page
in
1.
yeah,
the
okay.
correct spot.
All right, where am I? Page 1, line 26.
Okay.
So there we go. Page 1,
All right, read it again.
line 26, where it says believed by the pharmacist to have the effect or possible effect of terminating. Line 26, page 1, section 1. And insert instead the following: to terminate. Members of the committee and Mr. Chairman, I'm so sorry. I was reading from the very successful version of the same Senate bill that passed, and once again with bipartisan support, unanimously.
Did we get all that down, Legislative Council? Okay. And you're making this in the form of one motion, is that correct?
Yes, I am.
Okay, you've heard the motion. Hear a second. Okay, any further discussion on the motion? Okay, all those in favor of adopting the motion say aye.
Aye.
Those opposed, like sign.
Aye.
Call for the ayes and nays. Those in favor of it, raise your right hand. 4. 4 for. Those opposed, same sign. 4, 5. 5. Motion fails. Representative Graves, are you prepared to make a motion?
Yes, sir. I'm going to incorporate Representative Tumblin's motion also. On page 2, line 3, after the word person, we would add and or his or her employer, then semicolon, provided, however, that the pharmacist shall make all reasonable efforts to locate another pharmacist who is willing to fill such prescription or shall immediately return the prescription to the prescription holder. Thought they'd make it easy for you.
Okay, you've heard the motion by Representative Graves. Do I hear a second?
Second.
Okay, those in favor say aye.
Aye.
Those opposed, like sign.
No.
Motion carries. Okay. We have a bill with an amendment, so I'll entertain a motion that we pass out the House Bill 1445 as amended. A second?
Second.
All those in favor say aye.
Aye.
Those opposed, like sign.
No.
Okay, I call for the ayes and nays. Those in favor of the bill passing, raise your right hand. 1, 2, 3, 4, 5. Okay, those opposed, like sign. 1, 2, 3. Most of the bill goes out with a do pass recommendation. Thank you, Representative Mills.
Thank you, Representative Mills.
Okay. We got one other bill to bring, if I can find the, what bill number is that? House Bill 1385 by Representative Hurd. Representative Hurd.
Thank you, Mr. Chairman, members of the committee. Appreciate
Hold
you.
on just a minute. Let's kind of let these folks clear out that want to.
We'll let all of them leave.
Don't want to interrupt or distract anyone from. Okay, I'll let you proceed.
Happy to see the room has evacuated a little bit. Mr. Chairman, thank y'all, and members of the committee, thank you for hearing my bill today. I bring to you House Bill 1385. Just to go back into the history of the way this bill came into being, going back about 6 months ago, last summer, talked with several people about the issue of building permits issued throughout the state. As you travel around the state, you'll see areas in rural Georgia that are glad to have construction going on and have pretty much no plan review process whatsoever, to where in some of the metro areas, in order to get a building permit or a site development permit, can take anywhere from 6, 8, even 12 months. So there's great disparity across the state in the process of site development and building permit issuance. So over a period of the last 6 to 8 months, we've gone through an effort of trying to evaluate that process and bring it up to a state standard so that we can have some consistency throughout the state. Just a little bit of history on myself. As many of you know, I practice architecture as a profession. I have been registered in approximately 14 states throughout my career. Have done construction projects from as far south as Miami, Florida, to Maine, and as far west as Los Angeles. So I've had a great deal of experience in seeing what the standard is across the state, across the nation, related to how long it should take to review a set of contract documents and issue a building permit. And in frustration with the disparity across the state is why I'm here. I started working last summer with Mark Woodall, who's with the Association of General Contractors, who has gotten into great detail on this bill and has assisted me in putting together the document that we see today, that is LC 282990S, a substitute that we're currently working on and have brought before the committee today. I would ask that Mark, if to the pleasure of the chair and the committee, go through the details of the bill related to the permitting process.
Okay, be fine. Mr. Woodall.
Thank you, Mr. Chairman, members of the committee. Mark Woodall, Associated General Contractors. Real quickly, I want to talk conceptually, as Representative Hurd said. This is real easy to talk about, that when you've got a block and getting something done, hopefully identifying a process to have a professional do this when government doesn't have capacity to provide the service. But when you start putting words on paper, it gets a little complicated. I apologize for the additional 6 pages that you have in the substitute, but we asked for input, and we got it. I want to tell you who we've been working with. We've been working with the Building Officials Association of Georgia. We're working with the State Fire Marshal's Office. We've been working with GMA. We've been working with ACCG. We've been working with the architects, AIA. We've been working with the consulting engineers. What you have in front of you, again, the biggest change from the 7 pages that was introduced in this committee substitute we've taken the process that was listed in the building code section of the bill and restated it in the fire code section. So that's why it's grown to the extent that it has. I'm going to run through the process here. Again, when we spoke about this a number of months ago, we immediately went to the fire officials and the building officials and says, conceptually, would you have a problem with this? If we were willing to pay an additional fee for a licensed professional, and we would have the appropriate checks and balance in place, when government can't provide that service in a timely fashion, for the applicant, the permit applicant, owner or contractor, to pay an additional fee above and beyond their original permit fee to get this done. And the two comments that came back from the building officials and the fire officials were this. One, if we're doing a good job, if we're turning around those permits in a timely fashion, we don't believe this should apply. We agreed with them. Okay. Number two, there are certain type projects that ought not be eligible under this process. Things like jails, things like hospitals, very complicated things that impact national security. So that got us started. And with your permission, Mr. Chairman, I'll try and run through this bill very quick. Again, as I said, this law is modeled after a Florida law. And a number of years ago when Representative Westmoreland, Congressman Westmoreland was here, we worked with those same groups and got a bill done that when a local jurisdiction can't provide timely inspection, it allowed for private engineers within their area of practice, structural could do structural, electrical could do electrical, to provide that inspection service. So we went back to that same section of the code, and now we're also addressing the front end, as Representative Hurd said, in some jurisdictions, and take upwards of 6 to 9 months. So what the bill says on page 2 to begin with, when a permit applicant comes into a governmental entity to get this permit, basically if the governmental entity can provide that service in 30 business days, so not regular days, business days, 6 weeks, and they have the desire to provide that service, the rest of this bill doesn't apply. Okay, if they can provide that service within 30 days. If the governmental entity says we are swamped, we've had a rush of activity, we can't get to you for 6 months, it allows that party at that time to go hire a licensed architect and engineer to provide that plan review service. Within this section of the bill, it also says it's a complex project. 30 business days is not going to be enough. If the applicant and governmental entity mutually agree to extend that time frame, they have the ability to do that. At the bottom of the section down here, starting on lines 33, if a governmental entity discloses to a permit applicant that they can provide that service in 30 days and they are not able to, when that 30 days expires, they are obligated to give the applicant a project initiation permit, like a foundation permit, the ability to get started. And what it says, they have an additional 20 business days to get that full permit review done and issue the full permit to go forward. These time frames that are in the bill were negotiated again with the building officials and with the fire officials, and we're pretty comfortable with them.
It may be better if we eliminate him on the other end. So
I'd be happy to.
Okay. Yeah. Okay.
Yes, sir. I understand.
Just let me ask you a question about this section. The first section you just explained. This is related to housing and anything that you're going into for government agencies for permit.
It would be related to anything that governmental entity does a plan review on in order for you to get a permit to do construction.
And this bill says that if they can't deliver in 30 days, that you can hire a professional who will sign off on it.
It gives you the option,
right,
if you want to pay an additional fee, to hire a party to provide that service. And later in the bill, you're going to see where that does get submitted to the governmental entity for them to review the work of the private plan reviewer. So it's
and the extra fee go to the government.
Correct. And they are going to collect their building permit. They're going to collect their fee, and I'll show you in the bill where that is, even if I am going and hiring this private provider.
Where did that put the person who can't afford the extra fee to hire a professional in the sense of getting a permit?
It is an optional program, and again, if the governmental entity is providing timely service, the applicant is not going to incur that additional cost to do that.
Representative Dean, to respond to that, in the construction business, time is money. And when the time it delays to an extended amount, the applicant actually is going to be saving time, thus saving money by expediting the process.
But I'm still saying that because we're setting up now a system where folks who have money that's in the building and could get a permit at a timely fashion, and those who can't will stand in line like they always stand in line, and they're gonna lose money because they can't pay for that extra profession. And that's my concern. And so I'm just, I don't want to argue the point, but
I understand your point, and I think the system will be unburdened to a point where it will help all.
So what happened when the professional that you hire signs off on it, then the government signs off on it? Something go wrong, who's going to be held responsible?
Well, it's an excellent question. I can answer it now or get to it later in the bill.
Get to it.
Because it's in this section, so you need to answer now.
It's not in this section, but I'd be happy.
Okay, not in this section, okay.
Mr. Chairman, proceed.
I think proceed on. Representative Dean, the chairman makes observation, if a person can't afford for these plans to be paid, he ought not be in the building business because he has to get started. So anyway.
I understand, but I mean, we had the same problem. I mean, builders in Atlanta have the same problem every day, going over to City Hall, getting a permit. But what this bill does is set up a system that says that if I got money, I can hire professionals to do it for the city, pay the city the extra money to review it after the professionals look at it, and move the permit further.
Representative Dean, hopefully what it does, because it's largely a capacity issue, if you're freeing up staff's time in that jurisdiction, they're going to be able to do a better job doing it more efficiently for those projects they are reviewing, because you've taken a portion of them out of the mix. So hopefully if you've only got 3 people doing plan review, and there really should be 10 people doing plan review, if you're taking out a portion of those projects now that are being done through the private sector, those folks are going to be able to get to those plans faster.
How much of government was involved in your, as you put this bill?
Well, it grew from 6 pages to 13 pages with their help.
With government help?
Yes, sir.
Let's go ahead, proceed with that.
Number 2, on page 3, basically requires the party providing the review to do it as thoroughly as required by the local jurisdiction. Number 3 on that page, again, talks about the fees. Again, they're still going to get their fees. This is an additional fee above and beyond what they charge. Number 4 talks about the different codes that are in play that they have to review pursuant to. And number 4, A and B, talks about the design professional is going to be required to submit an affidavit that's going to be developed by the Department of Community Affairs. It's going to say a couple of things. I am licensed. I do have, if that local jurisdiction requires additional certifications, I have those certifications, and I have the appropriate insurance that's required by this act, and I'm going to get into what that amount is. Again, that is above and beyond anything that happens at the local level currently. So that's 4, A and B. 5, again, we talked about insurance. The parties that are providing this service are going to be required to have an additional $1 million of liability insurance, errors and omission. So if there is something that goes wrong, not only do you have a licensed professional, hopefully that's not doing anything wrong, but you can sanction that person's practice act if they've done something intentional against their practice act, but you also have an insurance policy that's not there when this is done by the local, by government. Page 4. Again, and one other thing, they only can provide this service within their area of competency. A structural engineer can't be doing something in electrical, so forth and so on. Number 6 on page 4. Again, they're empowered to do any of those reviews that take place at the local government level. And I want to mention one thing down here at the bottom. One of the areas in law that we have that is above and beyond just having the architect or engineer seal regarding MPDS, our Soil and Erosion Control Act. Right now in the law, anyone preparing one of these plans has to have an additional certification. That's what this talks about here as well, that party, if they're doing an erosion and sedimentation control plan review, they would also have to have that additional certification as well to provide that service. Number 7. Again, this is basically a checklist of the things they have to submit to the governmental entity, the applicable fees, the documents required, and any documents. Basically, this process doesn't start, the clock doesn't start until the party submits all documents required by the governmental entity to start the clock. V, when this report is submitted to the governmental entity for review, they've got 30 business days to review what the private provider has developed. Okay? If they don't review it within that 30-day period, they're obligated to issue the permit. You come down here in C and D, if they identify deficiencies in that process, they are to identify what they are, notify that reviewer, and he has the option of resubmitting, or if there's an appellate body at the local level, they can appeal that process and get an interpretation from the Board of Appeals. The time frame that we're talking about, one of the things that's happened, and I think Representative Hurd can speak to this a little better than I can, but sometimes there's some jurisdictions that a jurisdiction will identify one little problem and they'll start the clock over again, where they could have identified and make you go through those steps that you just went through. What this basically says is it's a 30-day period, and that's a told time frame. So if you identify deficiencies on the 25th day, you've got 5 days left, plus an additional 5 days when I resubmit to tell me what the deficiencies are in the plan. And again, it's trying to get everyone on the same page to move the process along. Number 8, this is pretty much was existing law allowing for pre-qualification of the engineers that provide an inspection, and this is one that we worked pretty hard on trying to find an appropriate balance. There are some jurisdictions and there are some disciplines that require an additional certification above and beyond this professional license. And so what we agreed, and it's primarily in high growth areas, Gwinnett County, DeKalb County, Fulton counties, that if the local jurisdiction has required that additional certification on their personnel, that they have the ability by ordinance to also require that plan reviewer to meet that additional certification. And that's the language that you see at the bottom of page 5 on to the top of page 6. Number 10, again, there's nothing in this bill that limits anyone's public or private rights with regard to remedies. Number 11, this is a section, again, in this one, Mr. Chairman and members of the committee, probably still needs some work. We're trying to identify those projects that are out there that aren't eligible for this. And again, we're receiving input, and I personally think that this may need some additional work. Number 12, the governmental entity has the ability to say, we're not issuing your permit. This is not designed to code. And if they get out in the field and they find out that it's not being built to code, they have the ability to issue a stop work order. Stop it. Get a question?
No.
So, again, there's protections on the front end when you're submitting, and the governmental entities maintaining the protections to protect the public on the backside of it as well. And one of the things...
Excuse me,
yes, sir.
Let's go back up there to 11 now. You say that you need some work. Are you proposing that we delay action on approving it for you to work on some more, or...
No, sir. I mean, we're receptive to any project that someone legitimately feels it ought to be outside of it. This is the list. We have Dwayne Garris with the Fire Marshal's Office who helped us with this list, and Bill Chambliss with the building officials helped us with this list.
Okay.
With the state fire marshal office.
Yes, sir. Yes, sir.
So, Mr. Chairman, I guess
I think you're
I
wrong.
still want to know what input you've had with local governments.
Where is local government? We got Mr. Grubiak, and I think Lamar Norton was here with GMA earlier. That just popped out. Oh, there it is. They're better prepared to speak to that than I am.
Well, I mean, with Atlanta, I mean, you counties were represented, but not necessarily cities.
Sure.
Okay. So we planning on trying to pay today?
Based on what the committee feels, if we get a good explanation of this bill and everybody's satisfied with it, I certainly want to get it out of here.
Back down in 12, again, this is gives the authority to stop that project or not issue the permit And when you get down to A and B, and this is one of the things that GMA brought to our attention, at the local level, home rule, you have some jurisdictions that actually have an appeals board. If someone has a problem with an interpretation, they can go to that appeals board. An earlier draft of this bill automatically allowed for an appeal to DCA, Department of Community Affairs. GMA says if we have a local board, we want it to stay there. We agree with that. And the new language that you have down in B basically says if there's a local appellate board, that decision stays there. If there is a question or an appeals and there is no local appellate board, you have the ability to appeal to DCA. And I think that's a good change to the bill. Number 13. The governmental entity is immune. They have immunity from those actions that are done and caused by this professional plan provider. So if the architect or engineer does something wrong, they're sanctioned. The governmental entity has immunity from any action that's brought forward.
So the person who issued the person profession that we're working on will be responsible.
If they have violated the Practice Act, yes, sir, they could be sanctioned by their Practice Act, their professional board, and if there was harm, and the governmental entity was not involved in that review,
but
and that
the government entity is going to review it after the profession they have.
Right.
So the government is going to be exempt.
That's what that says, yes, sir. With regard to
even though they reviewed it after the profession.
Well, quite frankly, right now, I think they're exempt under sovereign immunity. Jim, you want to help me with that one? Right? The difference in this bill, right now, if there's a screw up either on the front end inspect or review or the back end inspection and there's a harm, the governmental entity doesn't have any liability. This is where there's a licensed professional that has a license that can be sanctioned, and that individual has an additional layer of insurance that's there to protect the public as well. That's not there with the local government. 13, we just talked about that. 14, this basically says we talked about the ability of local government to pre-qualify, but it's tied back to whether or not they require that additional certification on their personnel. If they don't, they can't come up with additional things saying you've got to jump through 20 different hoops to do this in my jurisdiction. 15, again, they have the ability, particularly if it's an immediate threat, poses an immediate threat to public safety, to issue a stop work order, again, to protect the public from any wrong. 16, again, talks about if there's going to be discipline against these folks, you're going to be disciplined by their professional licensing board that are under Secretary of State's office. Mr. Chairman, number 2, section 2 is basically everything I just told you for local building officials, but is specifically applicable to the fire service. The differences in the bill, if the affidavit is going to be developed by the fire commissioner's office. Since we have a state fire marshal, the state entity is going to have the ability to develop rules and regulations when it applies to state stuff. At the local level, local fire folks, they're going to have to go through that ordinance provision that we spoke about. But for the most part, the timeline that I outlined in the earlier part of the bill on page 8 is the same. Again, they're still going to get their fees on page 9 and D. The affidavit, as I mentioned in E on page 9, is going to be developed by the fire commissioner. Again, they're going to have this affidavit that they submit and that they're meeting code for the fire safety standards and accessibility standards. F, they will have the same insurance required to provide service in that section that we had in the earlier one. G, again, this is the list of projects that are exempt from the process. H is their checklist. When you submit your report, it has to include these items, so they're checking off to make sure that stuff's been done. And starting in H double I or 5 double I, again, is that time frame where they're reviewing the private plan reviewer's submittal.
So let me ask you this, why? Go back on your list of exemptions. And why are we exempting government buildings and stuff like that, which cost taxpayers money? Even if that, the permit process is slow, some go wrong, change, the whole 9 yards. Why are we exempting them?
Well, they're still going to be reviewed, but they're going to be reviewed by the governmental entity. These are projects that they've deemed, the governmental entity said, we don't think that this should be eligible for the private sector. Dwayne Garris, you want to answer that? If I can answer it better than I can.
Yes, sir.
Dwayne Garris with State Fire Marshal's Office. the buildings that were exempted, the reason they're exempted is there's a federal contract with the state to deal with those particular buildings, and we didn't feel like we could execute those services beyond the federal contract.
So, but my point of it is, if you think that this is good for the private sector, because it saves the contractor money and saves the person who getting the house built or whatever they get built, it saves them money. Why are we, I still don't understand why, because the government spend a lot of time in approving contracts and permits and stuff like that. I don't understand why this is good for the private sector, not good for government. I just don't. I mean, I hear you talk about the federal law and all of that.
There are federal provisions in the law that contract with the state that they shall do these particular buildings due to federal standards that we're charged to enforce.
I got you. Is there anything in here that a government can opt out of this? For instance, if the city of Atlanta building department who issue permits don't want to comply, can they opt out?
If they, when a party came into the city of Atlanta to get a permit, says we can't provide this review in 30 days, they have the ability, if they want to, say you can immediately proceed with hiring a licensed design professional to do it. But then you submit, and they're obligated to review that party's work.
This legislation forced the city of Atlanta building department, according to this legislation, to operate under these procedures.
Yes, sir.
Didn't you say if they were doing a good job, meeting a certain standard, they didn't have to?
That's correct.
That's the opt-out.
No, that's not opt-out. That's somebody else setting the standard for the way the city of the government operate in the sense of permit that private sector operate in the city of Atlanta. But you don't have to build in the city of Atlanta.
Argue with him, not me.
I'm not arguing with you. Brought it up. That's me. That's try to answer the question. You don't have to do business in the city of Atlanta. Because what you basically saying is, I want to do business in the city of Atlanta, but I'm going to set your standard for how you have to respond to me in a timely fashion for the permits and stuff like that. And I'm not sure that's good government for us, the city of Atlanta, because what the city of Atlanta do is trying to protect the citizen, you know, in construction or whatever.
Yes, Mr. Chairman, and going back to the purpose of this bill is to, if you'll recall last year, we worked extremely hard on getting through the statewide contractor's license, which was, I think, a great thing for the state of Georgia. Now we're moving on to the second level where we're putting in a statewide standard for plan review and permitting, so that not only in metropolitan areas but also in rural Georgia we have a standard that we meet related to what the quality of plan review is that goes into reviewing those set of documents. And we're in the case of the city of Atlanta, they have, if they can do it expeditiously, that quality standard will probably go up a bit because we've got higher levels of certification. The people doing the review are going to be actually more qualified than the plan reviewers are now in those municipalities. So the citizenry is getting a better quality job in a more time efficient manner. And then the next piece, moving forward, now we've got a contractor licensing that's set up. We've got a plan review process based on not only in the way buildings are designed. There's two codes that generally apply to a building. There's the Georgia Building Code and there's the Fire Safety Code, which the Fire Marshal's Office reviews. There's no oversight of building plan review, no statewide oversight of that. And what we'll be doing next year is moving forward with the DCA, the Department of Community Affairs, so that they will have, through their regional offices, oversight of the building plan review process also. But that's a bill for next year to move this onto a better plane.
But the bottom line is this. The state of Georgia now is going to dictate to the cities how they run their building department and how they have to issue a permit to a contractor. That's basically what this bill is.
We're trying to issue a statewide standard.
But if you do business in the city of Atlanta and you get a permit, you follow the rules of the city of Atlanta, governed by city council, and order. Under this legislation here, the state of Georgia becomes the standard. Because you set the standard through this legislation to tell the city of Atlanta what to do when it issue a permit, how long they have to issue that permit.
The state sets a statewide minimum standard, and the city of Atlanta can go beyond that if they so choose.
No, we ain't talking about Yoma. We talking about the state of Georgia dictating to the city of Atlanta how quick they have to answer to a private person who walks in and wants a permit to build a house, build anything else. Not a government building, but build a building. Right now, this is government under the city council of the city of Atlanta and the mayor's office.
It requires the city of Atlanta to perform to its citizens. Yes, it does.
And the state to set that standard.
Yes, sir.
But those,
time,
if I understand it, Representative Hurd, that's nothing changed about the standards. If these people want to sit and wait, they can wait till doomsday. But well, yeah, you can if you want to do that.
That's right.
All they're trying to do with this thing is to expedite a contractor to allow him to do his work.
What they're really trying to do is, if I got money and I can go to City Hall and get a permit, and the process is beyond 30 days, I can pay a professional to do what government been doing and get a permit and jump in front of somebody else.
What this does do for the city of Atlanta, for any county or municipality in the state of Georgia, it provides a higher level of plan review, and it's to expedite the process for the individual, and then it saves the department money in that plan review then is paid for by the person requesting the plan review, and saves the department so that people are loosened up to do the backlog of the work by those that do not choose to pay.
One thing I hear you saying is that all of us know that we got a problem. We got a booming business in Atlanta, and yes, we might not have enough employees, but it's not the right of the state to come in and set the standard for how we run city government.
Let me just interrupt here. We've labored this point. We could stay all night on, but let's go ahead and move through the bill. And if we have an argument after that, Representative Dean, maybe you can get with the author and work that.
I'd rather get with my city government before I pass on this bill.
Mr. Chairman, again, page 10 is the time frames with the bill. Appeals process under fire would be appeal to the State Fire Marshal's Office versus DCA. I is the pre-qualification process. Again, if it's the State Fire Marshal's Office, they have a code that gives them the ability to promulgate rules and regs to do that. Page 13, again, J, it's not limiting the rights and remedies for anybody. K, again, they have the ability to issue a stop work order.
He's on 12.
I'm sorry, I'm going too fast here. L, again, immunity to the fire service if one of these parties has an error regarding their work, that the governmental entity shall not be held accountable for that. M, again, talks about that their ability to have standards is going to be tied to that pre-qualification standard and not have additional requirements. N, again, the ability to immediately, stop there's immediate public safety threat. And O, again, that these folks will be sanctioned by their professional licensing board, except the very last line. Also, again, the Fire Marshal's Office has the ability to promulgate rules and regs governing their portion. And I just, real quickly, Representative Dean, I can't say for City of Atlanta, but I was in a meeting with Fulton County, and let me tell you what they're doing now. That activity peaks and valleys as far as the applications that come in. And Fulton County right now is outsourcing plan review to a major AE firm in town, Lockwood Green. When they get over, they can't handle the capacity, they're outsourcing that right now. When they get caught back up, then they're providing that timely service. We see this as a win-win. When the government can't provide that service, there is an option to go around that. But they have all the checks and balances with review. They have an additional requirements for education, additional requirements for insurance. They are getting their fee. But it is totally optional for a party to do this. If they want, time is money, to pay that additional fee to get it done in an expedited fashion.
And Mr. Chairman, in closing, obviously a bill of this complexity, it's hard to get to a point where it's perfect, and we have not got it to a point where it's perfect. However, we've been working long and hard, and we feel like we have a very good bill here. We would like to request the committee's favorable review of this bill.
Okay. State Fire Marshal asked you the question. You reviewed this, and a lot of this bill pertains to the State Fire Marshal. Are you comfortable with the protection, the checks and balances in there as far as your department is concerned?
Yes, sir. We worked with the ACG quite well, actually, several nights on this. We do have two areas that we need clarified a little bit on page 12, line 27. Due to a provision already provided for in the statute dealing with the appeals process and stuff, after the word accept, the words as provided for in code section 25-2-12 and needs to be added there. Line 27, after the word accept, the words as provided for in code section 25-2-12 and needs to be added before the word appeals. And then also on page 12, line 36, the words subparagraph and the provision H of needs to be stricken, and that will allow for the regulations that are otherwise provided in this section. So it would read, except as provided in this paragraph, and that will take care of the problems.
Any objection from the author on those two amendments? Okay. We'll need to see. Okay, thank you. All right. Anyone else to speak to this bill? Come up and identify yourself and who you represent.
Good afternoon, Mr. Chairman. G. McCrae with the Building Officials Association of Georgia, and I have a simple statement that we have worked with Mark Woodall and the contractors on this bill, and we are in support of it.
Thank you very much.
Any questions?
Okay.
That's correct. It's the association.
Okay. Yes, sir.
Yes, sir. My name is Tom Leslie, and I represent the engineers of Georgia. We've also worked on the team reviewing the bill. We're pretty comfortable about this. We've had provisions like this for inspections for 3 or 4 years. Many firms already do that work in a very analogous arrangement as this is. We've reviewed it. We think there's ample protections included in here, and we think it's a good bill, and we support it. Hayden Stanley with the Apartment Association had to scoot away, and he asked that I also express on his behalf the Apartment Association's support for the bill.
Good. Thank you very much. Jim? Folks that may not know you need to tell us who you are and who you represent.
Thank you, Mr. Chairman. Jim Grubiak with the County Commissioners Association. And really just wanted to also say that the Association of County Commissioners supports this legislation. We appreciate the authors' work on this legislation and the various parties that got together, put the time into it. A lot of work went into it, and I think it reflects a very good product, and we commend it to you.
Thank you. Yes, next.
Mr. Chairman, members of the committee, Suzanne Williams with the Home Builders Association of Georgia, and I rise in support of this piece of legislation, and we appreciate the opportunity to let you know that.
Thank you. Mr. Norton.
Mr. Chairman.
Yes, sir.
Members of the committee, my name is Lamar Norton. I represent the Georgia Municipal Association, this revolving line of folks running over here. But we did get a chance to have some input in this legislation, and we feel like it's a good attempt to address some situations. We currently use some contract people to do these plan reviews and inspections, and sometimes we actually contract with counties to do it in some locations. So it's a furtherance of doing this.
Mr. Chairman, the City of Atlanta is a member of GMA.
They are a member of GMA.
The mayor's first vice president?
She is the first vice president.
Thanks so much.
Thank you.
Okay. Yes, ma'am.
My name is Sally Bethea, and I'm the executive director of the Upper Chattahoochee Riverkeeper. And I don't want to spoil a roll here of everybody being in favor of the bill. There's one specific part of the bill that we are very concerned about, and that has to do with the erosion control plan review and, as we read it, inspections by the private providers. We very much appreciate being briefed by Mark Woodall a couple of weeks back, but didn't really see the specific language until really last week. As long as House Bill 1385 addresses plan review and inspections of land disturbance or construction activities, we are going to remain opposed to this bill. Upper Chattahoochee Riverkeeper has spent much of our 12 years working to keep the mud from construction sites out of drinking water supplies, out of fishing holes, and out of the streams and the lakes that add a whole lot of value to our private property. I know Representative Von Epps knows the amount of mud that comes downstream from Metro Atlanta into West Point Lake. And while there's been progress made, soil erosion is still a very serious pollution problem in our state, as anyone can see after a heavy rain. In fact, some statistics from the U.S. Geological Survey, they found in 2004, at one of their monitoring stations on Nancy Creek, which is near Roswell Road, more than 250,000 tons of sediment passed that one site. That's 2,500 railroad cars of mud. We have a problem. We all know we have a problem. We've worked, my organization and others have worked for many years to make the laws and the regulations that govern erosion control fair and clear and strictly enforced. We understand the need for certainty on the part of the regulated community. We understand the need for a level playing field and for timeliness on the part of the government agencies that are processing these permit applications. In fact, several years ago with House Bill 285, which was a major reform of this erosion control program, we in the environmental community agreed that the law should include specific deadlines for local plan review, permitting, and other aspects of the approval process, something like 35 or 45 days. We're not aware, frankly, that there are any major problems with this process. We're not aware that any local governments in Metro Atlanta or elsewhere are using some sort of retribution to hold developers up. If they are, there's a way to deal with that. Local governments can be decertified if they're not handling the erosion control process adequately. We do know that the user fees that are now collected so that local governments have enough people for staff to do this are not being totally appropriated every year by the legislature, and I hope you'll work to make sure those fees are in full appropriated. So our bottom line is that we would urge you to hold this bill until all of the soil erosion provisions are out of it. We think that there are other ways. If there's a problem with a recalcitrant local government, there are other ways to deal with that. We think it's the government's responsibility to oversee this important program that protects our drinking water supplies. And finally, that we don't see that complicating this already complicated program with additional parties is really the way to go. Thank you.
Before you leave, I don't know where
Yes,
you're
sir.
talking. Refer me to where you're talking about in the bill about the soil erosion.
There are, I think I've left it back there. There are 3 places, and my colleague here is also going to be speaking about this. There are 2 places where the, thank you. And I may have the wrong pages because I don't have the exact brand new version, but there are 2 places in Section 1 where the Manual for Erosion and Sediment Control in Georgia is described. There is a place in page, I think it's 4, where they talk about private professional providers. Soil erosion and sedimentation must take the NPDES training courses, and so there may be a couple more places. As I said, I'm not a lawyer. Jennifer is, and I'm not sure those 3 are the only places where we'd like to see the removal, but certainly the rest of this bill looks like something a lot of people have spent a lot of time on, and sounds like it's something that needs to go forward. We feel that we've spent a lot of time on this erosion issue with the regulated community, and it doesn't need to be part of this bill. If there's something that's broken out there with some specific local government, we can fix it another way. We need to get these local governments funded by the user fees and getting people's permits and plan reviews done, and I think it's not a good idea to involve these third parties in the review.
I don't understand, though, in your statements, I don't see in this that they're weakening any ordinances or laws that are on the books now. I may be reading it wrong, but that doesn't affect or weaken anything that the state of Georgia has mandated that I see.
No, it involves a new group of folks, which are the private professional providers.
And
exactly.
They're supposed to be well qualified in all the same thing that anybody else does.
Well, I mean, it sounds
Okay.
good. It's one of those things that sounds good, but I've been working on this issue for a long time. And, I mean, I think we need to have local government people who are trained. We have enough people, and they're looking out for all the public's interest, and I think they should be responsive to the development community. And if there's a problem, then we need to deal with it other than handing it off to some qualified professional paid by the developer. Yes.
Okay.
Oh, excuse me. Thank you. Thank you.
Hi, my name is Jennifer Pennington. I'm with Georgia Center for Law and the Public Interest. I'm a staff attorney, and we represent organizations like Sally's organization, Upper Chattahoochee Riverkeeper, other riverkeeper groups all throughout the state. And as I am a lawyer, and you saved the most boring part for last, but I would like to talk a little bit about the legal implications of the bill in terms of how it contradicts with existing law. And I think this will hopefully address some of your questions, Mr. Chairman. Basically, what the bill addresses are any plans, and it just sets it up right away, if a governing authority cannot provide plan review. And under the, I'm using the acronym GESA, Georgia Erosion and Sedimentation Act of 1975, there has already been a standard set throughout the state of Georgia for how erosion and sedimentation control plans should be reviewed. And as Sally described, this has been a process that Department of Natural Resources Environmental Protection Division has been going through with various stakeholders over the past few years, and actually came up with what's called the General Construction Permit for construction activities in Georgia. And anyone planning to build a large community or it's basically more than 1 acre of land disturbance has to follow this general construction permit. And one of the requirements is that they submit an erosion pollution control plan to the local government. And what EPD has done they have required local governments to create ordinances that are as stringent as are the Georgia Erosion and Sedimentation Act, so that in each county there is already the standard for review of erosion and sedimentation control plans. So the bill, I understand the goal of the bill is to create a state standard, and with due respect to Representative Hurd, that already exists in the realm of erosion and sedimentation control. As Sally mentioned, we are not aware of local governments purposefully or willfully withholding approval of plans in order to delay development. In fact, as I'm sure you're all aware, development is rampant throughout Georgia and the rural communities, coastal, from the North Georgia mountains all the way to the coast. So I would urge the committee to, as Sally stated, remove the portions of this bill that deal with erosion and sedimentation control in the state, because that standard has already been set under GESA, and if this bill passes, it will create a contradictory scheme. The timing for review has already been established in GESA. For the local governments, they have 45 days to review the plan, and this will create a contradictory timeline. And instead of making it easier for local governments, as I understand it might in the building realm, for erosion and sedimentation control, it will only complicate the issue for local governments. It will require them to send written notice. If they don't do so, the plan will go forward. And it just creates a lot of contradictory language and a contradictory timeline with existing law. So if there are any questions, I'll end on that.
Representative
I don't have
Dean,
no
short.
question, because I think you're exactly right, but what I do want to say is, make this statement. I don't want nobody to think that I oppose us doing something about the permit process and on a timely matter, nothing like that. I'm for that. And we was on in a governmental relationship, I voted for the, license of buildings and stuff. But I would like to see what my government, which I represent the city of Atlanta, I haven't been able to get anything out of our government. I don't even know what because I hear nobody talk about the city of Atlanta being involved in this process. And I want to be sure before I vote on this legislation. And I know that the city of Atlanta have had some input, even from the erosion part, because we've spent out millions of dollars trying to meet the federal regulations and stuff. And I don't want to see us in state government just rush something through. I know how business people and builders have been so frustrated with the long process
You gonna
of
second it?
permitting and stuff like that. But you just don't throw the baby out with the bad water because you got a problem. And if you work as hard as you say you work, it shouldn't be a problem for us to delay this. We should, at the city's on the same page with this, before we pass this legislation. And that's what I say to my committee.
Okay. Von Epps?
Is there an opportunity to the author of the bill to make sure that we allow for the 45-day provision for erosion from that perspective?
We're not changing that at all.
You're not willing to change that?
No, the provisions that we're promoting do not change that provision at all.
Okay.
And the government has final approval anyway, right?
Well, if I may just disagree with that, it does set up a separate timeline. The bill that you put forth requires... Right, but the problem is that your bill amends, your bill only amends the section 8 to 26G without addressing the alternative timelines in GISA. If the point of this is to come up with new timelines for erosion and sedimentation controls, then I would suggest that you would have to amend GISA as well. And I don't think, at least from your explanation, that Department of Natural Resources or EPD has been involved in these conversations at all, and it actually does alter the timeline significantly for local governments.
Respond to it, Representative Hurd?
Yes, sir.
Okay.
Actually, we're just looking for, we're by no means wanting to downplay the environmental protection that goes on right now. And while we're providing an alternative time frame with a 30-day plan review, if a developer or if that process is still available in a 45-day time frame. So I don't think we are trying to downplay that process at all. We're just trying to make for an alternative timeline.
If I may, Mr. Chairman, respond. Respectfully, it does create a separate timeline. The bill requires 30 days for the local government. 30 business days. That is still a different time frame. For them to respond to the local government, then after 30 business days must respond if they will or will not be able to approve the plan. That requires one additional hoop for them to climb through. If we're talking about making it easier for local governments to review plans, I don't think that your bill is the appropriate way to do so, in that it adds additional procedural requirements for the local government to go through simply to do their job. If at the time they're given the choice of saying, yes, we will review your plan, or no, we will not review your plan, if they agree that they will review the plan yet fail to get back to the applicant within 30 days, then there is what's called a project initiation permit that's granted. There's nothing in GISA about a project initiation permit. In fact, the EPD came up with what's called the General Construction Permit, which governs construction activities. There's nothing remotely appearing to be like a project initiation permit. And respectfully, with regard to the environmental community, typically the first thing that happens at a development project is trees are raised, streams are filled, wetlands are filled, and the dirt is flowing into the river downstream. And that's when the most environmental harms occur. So under this bill, it opens the gateway for developers to have this project initiation permit and create the most damage to the environment in direct contradiction to the general construction permit, the scheme that has already been developed by EPD.
Okay, I think we've talked about this now, and thank you for your comments.
Thank you.
Better ask it in a hurry.
Is there any way that we can separate those two pieces out without destroying the process that he's doing?
Oh, definitely. If the erosion and sedimentation control plan review process was eliminated from this bill, we have no other problems with the bill whatsoever. Through the process that currently exists. And that process is dictated under GISA and, as I said, through the general permit.
Okay, thank you very much.
Thank you.
Representative Freeman?
I just make a motion at appropriate time.
You got a motion to be made? I'd like to hear it at this time.
Make a motion to pass.
Okay, the motion do pass. Do I hear a second?
Second.
Okay, any further discussion?
Mr. Chairman, I know you made the motion to be paid, but I just think that this thing is so important that I don't know what we're worried about. And this thing is so important that we ought to be sure that our local government, I don't know about y'all, maybe y'all satisfied with that, our local government have an opportunity to sign off on it.
Any other comments? The amendments that the fire marshal had, Sean, did we get those down, or have you got those in writing that we can put with the bill?
I just want to know, was that?
As amended.
As amended now. Okay, Representative Hurd, you probably need to make this a motion to do pass as amended by the fire marshals too. Is that what we want to do? As amended?
The motion will be including the two amendments by the fire
Okay.
marshal.
All right.
That will become the committee substitute.
Okay, do I hear a motion that the amendments are accepted?
So moved.
Second?
Second.
All those in favor, aye?
Aye.
And opposed? Okay. Now, we come back to the motion then is to approve House Bill 1385. The committee substitute the House Bill 1385 as amended. All those in favor signify by saying aye.
Aye.
Those opposed?
No.
Okay. Ayes have it. The bill does go out and do pass.
Thank you, Mr. Chairman.
Good to work with you guys. Now, see, hey, Tom, see, I worked with you. You should have gave me a terrible bill.
I didn't hear that.
What terrible bill?
County,
you know what that
municipality, fire
marshal, you know what
or architect, or design, I think they've worked on that thing pretty hard. John in the business, he talks about these delays that they have in holding up these contractors. Now, city and county can just about stymie one if they want to.
If you don't come by at 5 or something, I'm gonna be in the office for a few minutes.
Be money from him for this.
That was the worst bill.
No, I've seen some worse bills.
But tell me, that was awfully close.
I think the fire marshal, yeah, okay.
it all down, but I'll go.
That was awfully close. Holy man.
We had it read down too.
I think we'd ever get out of here.
I don't know what
I don't think Roger wrote it. That's what everybody complains about the most, you know. Wait for the
Tim, thanks so very much for all you
Yes,
do.
sir. Appreciate your comments.
Thanks so much. I appreciate it.
Yes.
Are you glad it's over?
Glad that's over with. Yeah, where you feeding me tonight? Where we going to eat?
Just come on down, I got some.
No, thank you for your service. I appreciate you running back and forth and
We ever gonna have unanimous vote? Mr. Keeper of the Journal, I vote. Boy, it was hard.
So that's existing